So I'm going to keep talking anyway, and maybe the gentleman will get this turned on. We're seeing huge changes happening in the delivery of legal services, but not just legal, conflict-related services. We're seeing a lot of different professional roles developing. You know, I think part of what may be seen as a kind of golden age of professional criticism and change is the fact that so many of these roles are changing and the boundaries are changing. There you go, a little noise. And there's also obviously a great deal of additional competition and insecurity amongst people as they try to carve out their niche and provide something that they can actually see as being marketable and successful. And I think all of these factors add to what is already, as Bernie suggested to begin with, perhaps the natural defensiveness that we have towards criticism. You know, we don't necessarily enjoy being told that things could be done differently, especially if we become attached over time to the way that we do them at the moment. So how do we deal with the challenges in facing criticism from the public, a public who I think are much more vocal these days in their criticism of professional services, but also from our own colleagues? You know, maybe that's even more difficult to face those kinds of critiques from our own colleagues. And as Bernie said, we want to think about how we should raise those critiques, which each of us has done in different areas, and what is a responsible way to respond to that criticism. So in order to do this, we're going to do the following. Each of us is going to talk about a particular experience we've had, if you like, a little case study, for 5 or 10 minutes each, and then we're going to throw the question to you and have you do a little bit of work, perhaps, because you may already be thinking of examples, I hope, in which you have seen criticism or suggestions about change, since change is everywhere at the moment, as being something that people had to really adjust to, not only sort of professionally, but also attitudinally, and in terms of maintaining their own sense of value and worth in the face of something that was critical. So, with that, I'm going to pass this on to Bernie. And you have to stand there. Speak into that. Or I'll criticize you.
Believe me, I'm used to that. So 10 years ago, I wrote, came out 10 years ago, was published a book I wrote called Beyond Neutrality, Confronting the Crisis in Conflict Resolution. I suspect a few people in this room are familiar with that book. Now, I knew I was writing something controversial, but I wrote the book because I felt like the field of conflict resolution was in many ways not reaching its potential. And so here was my argument, that we were facing a crisis, not necessarily an existential crisis, at least not immediately, but a long-term crisis, a developmental crisis, if you will. We reached sort of the period where we no longer were the new kid on the block that had a lot of sex appeal because it was a brand new idea, and the question is, what kind of institutionalization might we we're not trying to become institutionalized, and I thought there were a lot of limits we were putting on ourselves. And some of the signs were that many more people wanted to be mediators than could be. It was definitely let's say that the demand to be mediators was greater than the demand out there to hire or have mediators. And as somebody I just was talking about today said, the way you made your living for many years as a mediator is you did some mediation, you did a lot of training of other people to be mediators. And so there were a lot more people who wanted to be than could be. And a little out of balance of that, that's okay. Too much out of balance, that's a real problem. But we were not involved in many ways, in a significant way, in the most important conflicts of our time. So I was prompted to start writing this after 9/11, when I realized how we really were not that we had the answers, nobody did, but we weren't even part of the dialogue in a very significant way, I thought. And then I started thinking about that in many other ways, in many other respects, how we were very much part of a very limited role in the major conflicts of our time. And in many ways, our self-concept was limiting. So we saw ourselves as third parties dealing in the field of conflict resolution. And that's an important role, and resolving conflicts important, and being third parties is important. But I'll tell you that in most conflicts, that's not where people first go, including the people in this room. I found over and over again talking to mediators that they don't first go to other mediators if they're in conflict. It is something you go to fairly a long ways down the road, and so that if we don't begin to expand our sense of the kinds of roles we can play to help people in conflict and embrace those roles in our field, we were really limiting our potential to have impact. And of course, and I've now written a bunch of other stuff about this, the idea that our focus should simply be on resolving conflict was also limiting. There's many other ways in which we have to help people with it. And so I also wrote, and I didn't want to put all this on the slide, that some of our conceptual frameworks were pretty stale and hadn't grown with the times, and that there were a variety of other ways in which we were operating on some assumptions that were very different from what the public's assumptions were about conflict. And so if anybody's read this, I used to always joke with people, look, you have to get through the first 75 pages of this book without committing suicide. Afterwards, it's a fairly uplifting book because it does, I think, show a way towards the future. So that was the argument. The response. Well, from many people, mostly people say nice things to you about your own book, but not always. It was thank you for putting into words what I was feeling, that we needed to have this articulated, it needed to be put out there, it's important. But from many others, not just I disagree with you, I disagree with your analysis, I don't think this is a problem this way, maybe you could have thought about it a little differently, this is the advantage of having it. I mean, I had some of that. I mean, one of the most interesting ones came from people, from Peter Adler, some of you know, who said, I don't think we are a field. Why should we be a field? Why do we care about ourselves as a field? Interesting one, made me think about. But a lot of the other ones were, you are betraying the field. And so, these are some little things people said. A very famous person who's written lots of books about conflict and conflict resolution, not so much in the family area, and that's all I'm going to say about this person, but he said, you have made all of our jobs a lot more difficult. We will have to work hard to undo the damage you have done. And he wrote this not just in a little note to me, he wrote this and he circulated this to as many different people he could find. Before the book came out, because I wanted to know what he thought about it, I'd send him a copy, and he sent this to everybody he could think of, and I suddenly found that all these people had already heard from him, and I hadn't even published the damn thing. Another was, you are exaggerating and being melodramatic to sell books. Well, if so, I wasn't being exaggerating enough or being melodramatic enough. You know, I think I should have called it, beyond neutrality and sex and drugs. And then from quite a few different people, you're discouraging people who are excited about becoming mediators. You know, they read your book, and these are particularly people who are running master's programs like I teach in, for example, in dispute resolution, saying you're going to discourage people from becoming our students. So, what the nature of these, I think you will see, is not the critique of what I was thinking, but how dare I say this? So, what lessons have I learned? I'm not sure I've learned any lessons. You know, honestly, I like to think, I don't know that I wouldn't walk into it again, in the same way. But here's what I think. One is that no matter how you couch it, if you challenge the basis of people's identity, they will be defensive. Don't take it personally. So that's my saying. I didn't mean to be challenging people's identity. I meant to be building on it. But somehow the way I came across was I said, who you think you are and what you think you're doing is not okay. So the response to me that said somehow or other, I'm not okay for raising this must have been some way that people heard me saying, you're not okay. And I certainly didn't intend to say it, but I'm a child of the 60s. I insult people without even realizing. And so that's one. I think another lesson for me is, one response has to be humility. That I have to be willing to question our conclusions and to hear underneath what people are saying, what is it that they're saying that they maybe are having a hard time with beyond saying I don't have a right to say it. But I also have to be able to continue to assert my ideas even if I am attacked. So how do I both hear the message and continue to assert the ideas? How do I continue to be very clear about what I believe to be true and continuing to say it, but also to hear wherein what often appears to me as a personal attack is still something legitimate that I should get my hands around. So I should welcome disagreement and criticism, but I think for personal attacks, sometimes you can just walk away from them, and sometimes I think you have to say that's not okay. That's not okay. And isn't this a little bit like what we have to do with people in conflict all the time? Doesn't this sound familiar to what we have to deal with when we're dealing with people in conflict all the time? And the other thing is to take the long view. And this is maybe where I'm a little further down the road than you guys are, which is, this is 10 years ago now. I don't think we should take the immediate response too seriously. I think sometimes the immediate response is really like this. And I think if we just say, let's see, over time, I'll be proved right, I'll be proved wrong, I'll be proved somewhat right, people will grapple with it. The worst response for me would have been for nobody to take any notice. And if people are going to take notice, some of it's not going to be very nice notice. So that if I accept that, that worse than being attacked shamelessly is not to be noticed at all, that at least I was attacked shamelessly. And that over time, it'll out. And, it's 10 years later. I happen to think most of what I predicted has been borne out, but that's because I wrote it, so obviously I think that. But nonetheless, I think those are some of the lessons I've learned. So that's my little case study, and you're next, right?
So my case study is still current, and Andy's kind of in the middle of the two of us, so we have some comparisons here. This is mine. I think most of you know that I've been working on, first of all, an empirical study with self-represented litigants in 3 Canadian provinces. And since the study reported a little over a year ago, myself and Sue Rice, my project manager, who's standing at the back here, have continued to work on something we now call the National Self-Represented Litigants Project, which basically has taken me all over the country in the last 12 months talking about the research data, as well as working on discrete projects with court services and in bar associations, etc. And I actually began doing this by borrowing from Bernie, I'm not sure if I ever told him this, one of the phrases that I remember him using a lot when he was first talking about beyond neutrality and trying to defend himself against some of the arrows, which was that he was presenting a loving critique of the field. That sounded pretty cool to me, so I thought, I'll give that one a go. Well, let me just say it hasn't worked terribly well. And part of the reason for the session that the three of us are doing today is the session that took place this time last year at AFCC in Los Angeles, where myself and Andy were part of a panel that spoke about self-represented litigants, a plenary panel. And the response from the majority of the people who were there was very positive, but there was some virulent criticism in the session evaluations, which I managed to singe my hair again by reading on the plane on the way here. And so, again, this is part of the reason why we thought it was worth having a real conversation about this. So let me just give you the bare bones of this, which I think in some ways are fairly self-explanatory. So this is the issue. Empirically validated, not just by myself, but gazillions of studies now in Canada and in the US. Nobody in their right mind ever argues with this any longer because there is so much qualitative and quantitative data to support it. However, it is something which is obviously not good news for those whose livelihood rests on providing legal services at the current rates and in the present structures in which those are provided. This is something else that is empirically validated. We know this to be true in almost every family court in anything like a semi-urban or urban area now in any part of North America. More than half the people there are coming to court without a lawyer. I mean, the numbers are just absolutely staggering. and they have gone through the ceiling in the last 10 years or so. And here's the problem. Those people are a darn nuisance. And so in this particular example of dealing with professional defensiveness, I was dealing with both giving the bad news, which was, you know, it's impossible to negate these as empirical facts, but it feeds into an attitude that is very prevalent, I think, among some parts of the practicing bar, that this is thwarting them from doing the great job that they would like to be doing for people, and in particular that people who come to court without lawyers are doing so to create chaos, because they woke up this morning and thought, oh, I feel like being Perry Mason, let me at it, rather than they don't have the money to afford to pay for a lawyer. So I have found myself, and still find myself, constantly, and this is ongoing. I'm looking forward to a little break this summer, but I basically spend a huge amount of my life now talking to bar associations about these messages. And although some people are very open to hearing them, some people are very upset about hearing them. And some of those experiences, and I have to say, as a female, perhaps particularly, they are some pretty bruising encounters that I have. So the thing that we didn't talk about when we did the panel last year, intentionally, was some of the really deep dirt that is out there in my own study and others about criticisms of the profession. So having spared everybody that last time, and getting the blowback that we did, I figured, hey, let's just go for it this time. So here is some of what people say. And of course, you know, again, just trying to go back to the loving critique, I have spent 30 years of my life training lawyers, working with lawyers. I have many, many incredibly respected and dedicated people who work in this profession who I know and love. But these are the consistent complaints that we hear in the data from people who have used lawyers and now have run out of money. More than 50% of my sample ran out of money to continue to pay them. So this is what they say. Counsel wasn't doing anything. Now, you know, it's not that I'm trying to say to you this is objective reality. We know it's not objective reality, but it is their perception, and it is extraordinarily deep-rooted. So the very best case is we're not doing a good job of telling them what it is we are doing, because this is what people, intelligent people, think very consistently. This will not surprise this particular audience. Counsel was not interested in settling. The two lawyers were just saber-rattling, seeing who could piss the other off the most, is a typical quote in this respect, and simply not enough effort being put into trying to resolve the case. There is a great deal of very upsetting data in my very large qualitative sample of SRLs, half of whom did begin with counsel, that they complained that their legal counsel didn't listen to them, didn't explain their decisions to them. Now, I'm sure, again, that all these lawyers thought that they were doing that, or they felt that they were doing a much more efficient job by making a decision to go in a direction that would be maybe more in this client's interest, in their opinion. But there was such a huge disconnect between what people felt was being done for them in their own best interest and what I imagined their lawyers thought that they were doing for them that was in their best interest. And finally, you know, consumers today, as I began by saying at the beginning, are an awful lot more savvy and an awful lot less deferential than they were in my parents' generation. And there are many people who point out that perhaps completing a form isn't something that they should be paying $350 an hour for, given that they actually know that it's the secretary who does that anyway. So, you know, there are a few little kind of cracks here in terms of just what is the value of the work. So these were the consistent complaints. And I never show this slide normally. This has been buried, right? This doesn't come out very often. But even without showing this, as I say, there is a lot of upset at thinking about these critiques. So here is my response that I hear pretty consistently also. Again, I want to emphasize, as Bernie did, not from everywhere. But you are just lawyer bashing is by far the most common response. And the thing that I find very interesting about this, and one of the reasons that the three of us got interested in thinking about presenting this topic to you here, is that the expression lawyer bashing is used as a kind of toxic shutdown in much the same way that accusations of racism, sexism, homophobia are used in a way to stop the conversation. Once you're accused of certain things in our culture, you zip it, right? Even if it's unjust, you just know, I better not go any further here, because that is a really toxic accusation. And in the legal profession, lawyer bashing is a toxic accusation. It doesn't necessarily mean that it happened. It doesn't necessarily mean it was the intention, but it is a word that's used to stop the discussion. And I hear it all the time. Even when I think, God, I've been really kind here, I still hear that word all the time. You are portraying the profession, a little bit like Bernie said he had in some of his responses. I've had lots of people say that, this is disloyal. And then these three words on the bottom are the words that appeared in the small proportion, but nonetheless a small proportion of evaluations that we got to last year's session that were negative. And these were three of the most common words that we used. It was insulting, what we spoke about last year. It was boring. I mean, that's the one that offends me the most. How can this stuff be boring? I mean, you may hate it, but how is it boring? But you'd be surprised. There were 3 or 4 evals that said that what we did last year was boring. In fact, one said, all this call to arms is boring. But, that's what it said, and disrespectful. So these are some of the themes in terms of the response. Now, just like you're going to find with Andy, and just like with Bernie, this is the part that I have struggled the hardest with, and we have all done our very best, and we're going to throw it to you, of course, when we're done talking, to figure out what the lessons learned are here and what we can do to bring important but difficult messages to people in a way that they will hear them, because everybody in this room knows there's absolutely no point talking if people aren't listening. So we have to figure out how to get them to listen. Obviously, significant change means there's a great deal of uncertainty and insecurity in the legal profession. Obviously, I'm not sure what we do about that, but that is part of the context that has to be recognized in order to figure out how to handle this. The second point on this list, originally I'd written, don't shoot the messenger. And Andy pointed out that this sounded self-pitying, to which I pointed out, I feel sorry for myself sometimes doing this. However, it's a slightly better framed here, perhaps. The bearer of the bad news may take the brunt of the negative reaction. Now, maybe that is just part of the territory, which is, I think, kind of Andy's point to me. But this is hard. It really is hard. I mean, at this moment, I'm kind of a little tired out with this. So I think we need to factor into how we think about managing, responding, evaluating criticism, what it does to the people who are the people bringing the bad news. There are clearly strong vested interests in protecting the status quo. One of the things that I have been really very surprised about is the extent to which people who would accept without too much difficulty the premises that I put up here earlier, but are still very, very resistant to doing anything different about them. I mean, this was the implementation gap that Justice Cromwell was talking about. I think it's one of the real challenges that we face here, that we can all sit around and go, woe is me, no one can afford lawyers, and then we need to do something. And how do we do that when, in fact, the way the profession is structured at the moment, and this includes all of the people in the profession, the people doing wonderful work as well, it is structured in a way that protects those vested interests and the status quo. So what do we do about that, and how do we let any kind of incursions in, perhaps represented by members of the public and their views? And finally, people find it hard to hear the positive at the same time as listening to what needs to change. I did a talk just in the last month to my local bar association, which of course I should have realized. I mean, Sue and I have this joke about the places I go where I need protective clothing for the rotten fruit and that kind of thing. I didn't expect that today. I needed that today. But this was one of those protective clothing gigs, as we call them. This was my local bar association, which in some ways is always the hardest place to speak, is in your local bar. So I thought, I know what I'll do. I'll go in and I'll make them so proud of us because we're doing this project that gets all this national publicity, and everybody working on the project is from Windsor and Essex County, and they will be so proud when they hear this. So I do all this stuff about, la, 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 or all these news items, la, la, la. And then I get to the, yes, but I'm afraid people can't afford you. And that's it. Like, it's game over. So I realized that people really can't hear the positive part if they're also being asked to hear something negative at the same time. And again, this is a lesson that I think we know from our own practice in conflict. Okay, Andy, you're up.
No.
I'm the secretary to this group, you see, the woman.
What do I press?
Press that bit there.
That goes down?
Yes.
Okay, I can do that. Okay, so I thought I was giving the legal profession a present. Okay. Yeah, okay, so for those of you who don't know what collaborative law is, it's limited purpose representation. You'd call it unbundling in Woody Wosten language. You represent somebody only for the purposes of settlement. No, and if you don't settle, both lawyers must disqualify themselves. Either party can terminate at any time for any reason or no reason, and it's entirely voluntary. You have to sign a contract called a participation agreement where both parties agree to it. Okay. It grew as a grassroots movement in the United States and in Canada. And Julie did some of the most fundamental early research on it, basically by divorce lawyers who rejected the view that they were adversaries. They wanted to problem solve more. And it almost is exclusively being used in the divorce context. While there have been attempts to extend it to other areas, it didn't work. So I was asked by the Uniform Law Commission, which is one of the two most prestigious law reform groups in the United States that drafts model statutes for state representation, to be the reporter for the Uniform Collaborative Law Act. And this is a very transparent process that's done. It took 3 years. It was debated by a Congress of representatives from all the states twice, read line by line. Okay. What you have to understand about this is the Uniform Law Commission, which drafts the Uniform Commercial Code, the Uniform Marriage and Divorce Act, every uniform act that's in every law school casebook. It's one of the most fundamental entities. They did it to support collaborative law, which was being practiced by a significant group of divorce lawyers mostly in collaboration with interdisciplinary professionals. Why were they doing that? Why was collaborative law important enough for the Uniform Law Commission to take notice and ask for the drafting of the act? It's all the stuff Julie was just talking about, except it was the increasing expense and emotional cost of divorce litigation. And it was pretty clear from the data that some percentage of divorce clients do not want to fight. They want planning and settlement options, and there's some conflict along the way that they need to resolve, but they want to get past this and move on with their lives. The second thing is the data is absolutely dead bang clear that the more the parents fight with each other, the more their children go into the tank. I mean, that's like not debatable. There are many things about it that's debatable, but if they're yelling and screaming and fighting with each other, and that's encouraged by lawyers, that they get worse and not better. So if you have responsibly managed conflict, moving towards problem-solving solutions, you're going to get, you're more likely to get a better outcome for your children. Increasingly, as Julie just emphasized, in a different, in sort of self-represented litigants, the data is pretty clear that the perception of the profession is going downhill. Lawyers are regarded as conflict promoters rather than conflict resolvers in general terms. Now, that doesn't necessarily apply to your own particular lawyer, and it doesn't apply to every lawyer, but that's a major problem that's been going on with the legal profession, and it's pretty clear over and over again. People describe lawyers as getting in the briar patch with lawyers. They get scratched and they can't get out of it. So collaborative law seemed like a good idea, right? And it seemed like an idea that would catch the trends that Julie was talking about, and we could do something about it. So we drafted a statute through this process I was talking about. It was designed to set minimum standards for the participation agreement, informed consent by the clients. It included screening for domestic violence and informed consent. And above all, it created an evidentiary privilege for collaborative law communications. It's a technical evidence problem, but if the husband and the wife are perceived of as adversaries, what they say to each other in settlement negotiations in some circumstances can be discoverable and admitted in court. We tried to eliminate that so you could put a shield of confidentiality over the evidentiary privilege. So it seems sensible. Okay. All right. So the uniform law, here's where the fun starts. Okay, the uniform law, we held meetings. We discussed this with everybody. It was open, transparent, every lawyer group you could get your hands on. The Uniform Law Commission has a deal, longstanding deal with the American Bar Association. The American Bar Association is the largest voluntary association of lawyers, I think, in the world. 40,000 members, somebody, I don't have the exact number. And the deal is that the Uniform Law Commission drafts a statute. It goes to the ABA for approval. If it's approved, they go jointly to the states to have the states enact them. Now, obviously, it's much more perception is much more powerful if the Law Commission and the lawyers groups say together, this is good legislation, draft it. Okay? Now, what I didn't understand was how deeply embedded in the ABA the litigation section was, and how deep a threat they perceived the Uniform Collaborative Law Act to be. I did not understand that. Okay, I understood it the day I got to the House of Delegates before the ABA, and the head of the ABA litigation section called me incompetent, which was great. I go, what do you mean? I'm not competent. I know what I'm doing. I just drafted the statute that went through all these people. I'm a law professor. Okay. Couldn't know it because I didn't know what it was doing. And all right. But the main things that they were saying is it was inconsistent with a lawyer's duty to represent clients zealously. Okay. Lawyers also have a duty to problem solve and advise their clients and to present argument and to present rational alternatives. There are famous quotes from minor lawyers like Gandhi and Lincoln about encouraging settlement and how it was a rational settlement and how it's a major portion of a lawyer's duty. I got hit over and over again with, you're ruining the legal system. You're not representing your client zealously. Mostly from people who never practiced divorce law and don't understand that if you run out of money, you can't litigate anymore. Okay? Then they said it might be used as a strategic tool to disqualify counsel. Sure, absolutely, but it's a tool for both sides, and they both voluntarily agree to it. Then there was this is what I love, the regulation by statute threatened the independence of the bar. I was going, you're going to pass the statute and we're shackling lawyers? No, we're giving them more options to practice. We're giving them more ways that they could actually represent people and do things and legitimizing a problem-solving process. And, by the way, if you ever look at the statute books, there's bazillion statutes that regulate the behaviors of lawyers in court and out of court. But this was a bad one because it was inconsistent with the lawyer's design. Okay? Now, I never said this, okay? But it was an undercurrent of the duty. Julie talked about strong interests. There was a fear that the economic interests of lawyers were being hurt by collaborative law settlers because they didn't make money from litigation. Okay? Now, in response to that, it's very difficult to deal with fears that aren't articulated well, but it would come out in various ways and points. A lot of matrimonial fees are never collected because people are unhappy for all of the reasons they were talking about. The profession gets a bad reputation for spending money that it shouldn't be getting. Okay, it's not at all clear to me that you're going to lose fees if more cases are problem solved and settled and you have clients who are happier, okay, and give you a good recommendation. However, this was there. Okay, so here's what happened. The first time in a history, in a 70 or 80-year history, the ABA did not endorse the Uniform Law Commission's recommendation. It had substantial support from many leaders in the legal community, but the litigation section overwhelmed it, just absolutely overwhelmed it. Okay, which of course this I did not anticipate. So what has happened? Okay, this is great. The ABA is a voluntary association and is losing members. It just lost 4,000 more because it would not accommodate the collaborative lawyers. It didn't believe in them. It sent them a message that we don't believe in you. Honestly, from my perspective, it put the ABA on the wrong side of history. It basically said, here we stand, and we stand no further. We will move no further. Okay. Now, these are the same folks who are expanding the reach of transnational law, allowing lawyers to invest, non-lawyers to invest in legal proceedings, but they're not going to let somebody collaborate for a settlement. They're not going to endorse that. The result has also been that the legislatures, and this is, I guess, I don't know if it's good news or bad news. I can't kind of figure that out. The statute has been enacted in 10 states in 3 years, which for a uniform act is actually quite extraordinary progress. It usually takes 20 years to get 10 states to enact a uniform act. And when you say the ABA comes and says, we didn't endorse this, what do you think the legislators say? Okay, so this was a shoot themselves in the foot moment, I think, basically, but it was ugly, and the debate was ugly in a lot of ways. So what have I learned? Okay. The first thing I learned is lawyers are not one entity. There are many different silos and different points of view. And I wish I had anticipated what the litigator's point of view was. I should have anticipated their opposition. Most of them do not practice family law and did not understand it. And I kept wondering during the course of this debate if I had only arranged meetings between the litigators and the collaborative lawyers, maybe they could talk it out. Maybe. I'm seeing head shaking. Yeah, I kind of came to that conclusion too. But it sounds nice, doesn't it? I mean, you know, from a conflict resolution, I would brought Bernie in to facilitate the discussion. Boy, would I have. I honestly, I don't know what else I could have done. I mean, I kind of kick myself because I make my life trying to teach law students that there is a responsible way to be a lawyer. And yes, at times you have to litigate, but that's in family law. Last resort, try problem solving first, try collaborative law, try everything else first. I just don't know what I could have done. I certainly didn't like the personal abuse, but after a period of time that was water off your back. What I was really distressed by was how much the litigators liked the sound of their own voices. They kept making the same sort of what I would in New York call BS arguments over and over and over, and they said the same thing. And there was no way to penetrate it. There was no way sort of around that. But I'm still glad I did it.
Okay. Before maybe we go specific, we had some specific questions we wanted you to reflect on, but general comments, questions, responses to anything we've said. Yes. Well, I'm 68. Does that? Yes. I think there are a lot of environmental and systemic things, and I think in many ways we are, I'll speak about the conflict intervention field, which is what I now call it. We are both a profession and a movement in some ways. We are also, and I think this is true of all professions, by the way, we are also both about social change and social control. And those are tensions that we play out all the time. And so, I think what some of this stuff is saying is, let's be a little bit more movement than about social change, and we're running against some of the forces that are saying, yes, but we're also a profession, and we also have to exist to make the present system work. So yes, there are all sorts of other external factors: the aging of the graying of the field, the breakdown in all sorts of traditional dispute resolution mechanisms in communities and societies. There's a lot of other things that are totally not under our control. On the other hand, it still poses the same challenges for us. That's what I think.
Just as addressing this point about the aging. in the work that I've done over the last 15 or 20 years or so with lawyers, what's been very interesting is that age has not generally been an important variable in predicting whether or not somebody embraced change or not. And, we saw that, for example, with the collaborative law movement, that, in fact, a lot of the people who were moving into that area were people who had been at this 15 and 20 years, and they'd gotten so burned out with the adversarial model, that was why they were moving over there. I saw the same thing in my studies of mandatory mediation. Again, it wasn't necessarily the newbies. I think we have this kind of, I wish it were true, this idea that everybody coming out of law school is all turned onto this stuff. Not true. I think you see just the same kind of cultural conservatism there as you do with the older group. The only thing I would say is that in the self-rep study, what I have seen is a far more pragmatic approach amongst younger lawyers when it comes to earning money. And that's because they are carrying $100,000 of student debt when they graduate law school, and they darn well have to find some clients one way or another. So I think in that respect, age is important, but I don't think it's just about, I wish it were just about age and we could just shoot everybody over 60, but I just don't think it is.
Please.
66? It's interesting. Your question's great. My experience with the collaborative law people was older and younger, and the middle were the people who were the most rigid. Okay, the younger people in the American Bar Association Family Law section organized a rebellion when the leadership did not want to approve the Uniform Collaborative Law Act. They outvoted them. Of course, the leaders then went to the House of Delegates, which is where the vote was taken, and said, our section made us vote for this, but this legislation really stinks. Okay. I'm also a Marxist in a lot of ways. I deny that, but it's, the young people desperately need new service models. Okay. You're talking about a situation where 70%, 50%, some percentage of our collective people are not represented at all. Can you imagine if you go to a healthcare center, you've got 70% of the people who have cancer can't get a doctor? Okay, you'd be all up in arms, right? We would be. That's what we got. Okay, so they desperately need new practice models, whether they want them or not. They need to figure out how they're going to reach that 70%, because I don't think the government is ever going to fund legal aid enough to get those folks represented. And so we need a lot of flexibility, and we need a lot of alternatives, which are challenging, but the people most likely to adopt them are people who are sort of disgusted with the current or concerned about the current one, and the young. And the other thing I want to say, actually I should have said this earlier, and I guess I didn't want to criticize all the collaborative lawyers. How many collaborative lawyers we got? Okay, I love you. I do. Please. So this is tough. This is, what did you call it?
That's what Julia always says to me right before I'm about to take it.
Every time you look at a litigator, and say, I'm right and you're wrong, okay, I do it the right way and you do it the wrong way, okay, and I know that they brought that up to me bazillion times, okay. It was all the challenge of the. It was all the self-identity stuff that Julie was talking about. They brought that up to me over and over and over again, and they said, these people aren't real lawyers. And I go, oh, yes, they are. And they're doing a different thing than you are. But it really, and in part, we ADR people, and I consider myself one, we live in part by rejecting the court system. Okay, we say the court system is terrible. Come to us to help solve your problems. You're better off doing self-determination. I agree with that in concept. You should be doing self-determination. But there are also people who really need to go to court. And we need to clearly say that over and over again, because the litigators seize on they distort it. They're really good at that stuff. And they take words out of context, and that was the stuff that kept getting quoted back to me over and over again. Maybe you Canadians are more precise than we Americans, but it was a real problem.
So you wanted to say something back there, yes?
Well, I just want to say something controversial.
But a lot of us have been there. Well, here's what I would like to kind of focus our discussion on, just to refocus it just a little bit. It's this. I think these are the kinds of issues and discussions that we need to be able to have. And we need to be able to have them very frankly. But what we run into is sort of what's the right metaphor, a whipsaw, a chainsaw or something, of defensiveness. And I include myself there. I'm defensive. I get defensive when people, say things that and so the question really is, how do we put this stuff on the table where it really does attack, doesn't mean to necessarily, but people, at least based on what Julie said, they don't hear the positives, perceive it to be attacking their own sense of who they are, their own identity. What is it that we need to do to put it on the table and to respond to what we're hearing in a way that we can really then have a discussion that's really about change? Greg?
I hope that movie was equal opportunity bashing. He bashed everybody associated with the system. He bashed custody evaluators, he bashed judges, and he never mentioned any alternatives other than Sweden, right, if I remember correctly.
And I'd also I sometimes wonder why we don't have other expressions like client bashing or dentist bashing, or I just wondered about that.
I also want to say the expression that if you have a hammer, everything must look like a nail, I've used for mediators. That I was once on a panel at I think it was an ACR conference called, if mediation is our position, what is our interest? I mean, it's a very valid thing. Sometimes things are nails, but I think all of us have an obligation to understand that we look at things through the lens of the practice we like, and therefore we are, no matter what it is, collaborative mediation, litigation, surgery, that no matter what it is, we are more likely to see that the need is what we have to offer. And I think that it behooves almost all of us to sort of say, be careful of that one, because that can really lead you astray, I think. So, Andy, you want to have a minute for final reflection where we go from here?
First, I want to thank everybody. A lot of the for whoever, I'm sorry I didn't see you. Whoever came back from the abuse you suffered in Los Angeles,
over here.
We appreciate that. We really do, and we didn't mean to abuse you. The responses have been great. There's a lot of food for thought here. But I also want to say, I think we are in the middle of what Julie's described accurately as a legal revolution. I don't think it's over. I think there's a lot of stuff going on which we're actually actively debating in law schools. For example, the influence. We haven't even talked about the influence of computer technology. Julie did some, but on lawyer-client relationships. And that's all rummaging through, and also the legal job market, at least in the U.S., is terrible. And how they're going to get jobs, and law schools are shrinking, and whole bunches of things are happening that are very, the process of change is very short, much shorter, more dramatic, and is going to continue much longer. And we really need help, because I think I'm a big fan of lawyers. I train them. I make my livings from teaching them. I think they do multifaceted things, and I want as much help as I can get in helping that profession both serve its traditional values of like they did this morning, representing the young girls who were raped in Kenya. That was fabulous. Okay, that's exactly what lawyers should be doing and well. Versus, all right, let's fight about whether it's 2 more minutes when you pick up your kid. Okay. I mean, it's just different, and we need to recognize different approaches towards different things, and the help I've gotten today I really appreciate. Thank you.
I'm not sure this is on, but I'll put it here in case it is. I want to echo that as well. This has been great. I'm going to be thinking about this for a long time afterwards. Two quick things I want to say. One is that the lady who left in Los Angeles talked about starting in a place of respect, and I think for myself, and I think for each of us, but I can only speak for myself. That is a very important internal reflection. I feel like I have enormous respect for lawyers, but I also think that sometimes I let my sense of humor get a little ahead of me. So, you know, that's just an example of the ways in which, because I wrote down here, you know, what would that look like? And I think, you know, there might be a few different cultural norms here as well that I have to struggle with a little bit. The second point I want to make is that it seems to me that one of the things, and this comes from many of your comments, that we have to be able to do is to help people to be comfortable with being uncomfortable. And in a way, that was why we wanted to do this session, and not just to leave what happened last year kind of on the table. Because this is going to be difficult. You know, you were very eloquent on the massive challenge that you face now in practice in trying to adjust to your clients' expectations. I totally hear you. I have so much that I know what you're talking about. That's a huge challenge, and it is an uncomfortable place to be in, looking at so much change. And I don't know quite what it is that makes people more comfortable with being uncomfortable, or if that's just a tautology, but that's one of the things that I'm going to take away from this session and think about some more.
Okay, so my father's favorite joke was a guy who wants to go to his neighbor and borrow a lawnmower. As he's walking over there, he says, well, he's going to say, all right, but would you bring and fill it with gas next time and make sure you oil it? And by the way, where's that shovel? You bothered me. And please make sure when you mow your lawn that grass clippings don't get over onto my side. And he thinks of all the stuff, so he knocks on the neighbor's thing. The neighbor opens the door and he says, you can keep your goddamn lawnmower. And I think sometimes I'm guilty of that a little bit. You know, that when I'm trying to do these deliver what I think are important but controversial things, sometimes maybe anticipating the response makes me defensive, makes me less kind, and makes me forget two critical things. One is that I have to be providing stuff that's helpful to people. And challenging can be helpful, but you have to do it in the spirit of trying to be helpful. And then also the Gandhian principle that anybody who's your adversary is your potential ally, and you should always treat them like that. And I think those are kind of things that I'm not always, when I get passionate about something, I think I don't always embrace that very well. And so, and then I think I'll go back to what Greg said, you know, people are going to be defensive. That's okay. The response really is for us to hang in there over time and hopefully not end up in an insane asylum. Thank you very, very much. We really appreciate that.